Good morning, everybody. Good morning to those of you joining us this morning. This is our Conducting Redundancies Fairly webinar through WCVA. We are expecting quite a few more than this, so I'm intending to just sort of let people in as they arrive. So we've got about, well, over 30 signed up, so I'm sure there'll be a few joining us along the way. Just to introduce ourselves very quickly, we're both from Darwin Gray. So myself, I'm a partner and employment lawyer here at Darwin Gray. Then got Fiona Sinclair, my colleague, with me, who's a HR consultant. Good morning, Fiona. We're going to be sharing this session, so we'll be doing we'll do a split of the slides, and hopefully kind of complementing each other's areas of expertise. So in terms of some practical points to make, the session is scheduled for an hour. I expect we'll allow a little bit of time for questions at the end. Probably won't take up the hour, but there will be some time for questions. If you want to send your questions via the chat throughout the session, please do so. We'll probably deal with them at the end just to avoid any interruption to the flow. But also, by all means, sort of put your virtual hands up and raise any questions at the end if you wish as well. I am recording the session, so if you've got any objections to that, please let me know now. The recording will be available on request, so please get in touch if you want a copy of the recording. You can share with any colleagues of yours or any friends or anybody else. Likewise with the slides will be available, so please just get in touch for those. So without further ado, we'll press ahead with the session in the hope that others will join us as we go ahead. So in terms of what we'll cover today, we'll cover redundancies specifically, but redundancies in the context of COVID-19 and the pandemic and lockdown as well. We'll also discuss alternatives to redundancy, getting the process right, and then this wouldn't be a session involving a lawyer to do with redundancy unless there was some doom and gloom in there, and that's my very last point, which is the risks of getting it wrong. So that's the scary bit right at the end, before you get on with the rest of your days. So a little bit of context very briefly before we get into to this properly. COVID-19 and redundancies, I mean, I can speak for myself, and I'm sure Fiona would agree with me on this. I mean, redundancy levels during the pandemic have fluctuated greatly. I mean, there was a flurry of activity back in April and May of last year, right at the start of the pandemic and lockdown, where I was incredibly busy in assisting people involved with redundancy processes. Since then, it's fluctuated quite a bit. I mean, those fluctuations have tended to coincide with announcements to do with the furlough scheme. I appreciate that not all of you would have dealt with the furlough scheme, but or would have used the furlough scheme, but that's a pattern that we've seen. Certainly, from the statistics on the slide, those are undisputable that there has been an increase, and a significant increase, in the number of large-scale redundancies. So those are the ones that are recorded per se, because if you make 20 or more people redundant, or you're intending to make 20 or more people redundant, then by law you must inform the Secretary of State. So you must make a declaration to the Secretary of State, and therefore they get the statistics on those, whilst they wouldn't necessarily be getting direct statistics on small redundancies, as they might call them, which are 19 or less. Number of people unemployed, quite a significant figure, and the number of people on furlough, quite a significant figure as well. To touch on redundancies and furlough and the job retention scheme, I appreciate, as I say, that not all of you would have been utilising the job retention scheme. However, it is something that we've been dealing with quite a lot. Some basic principles of where redundancies sit with people on furlough. It is possible, of course, to make people who are on furlough redundant, and the normal rules on consultation and notice stand. In other words, consultation for the purposes of redundancy does not amount to work for the purposes of furlough. In other words, it doesn't bring your furlough period to an end. So you can be on furlough and still be consulted for the purposes of a redundancy process. A couple of crucial points to make. If you are paying a reduced salary during furlough leave and you're not topping up 80% of salary up to £2,500 a month, then the individual being made redundant would be entitled to their full pay during the notice period. And a quite important change that was brought into the job retention scheme back in December was that from December 2020 onwards, notice pay could no longer be claimed under the job retention scheme. So prior to December, employers could make an employee redundant and leave them on their, say, 3-month notice period and keep claiming under the job retention scheme for that 3-month period. That's no longer the case. So that's a significant practical shift that we've seen in terms of people's attitudes, employers' attitudes towards making furloughed employees redundant. So before we get into some of the more practical considerations of what a redundancy process looks like, I thought I'd start off with just explaining to you from a legal perspective, from a statutory perspective, what a redundancy is. And by law, a redundancy can be one of 3 things. So any redundancy has to fall into one of these 3 categories. Either there is a business closure, in its simplest form, that means your organisation comes to a close. There's a workplace closure. Sorry, could I just ask you all to mute, just so that we don't get any. I'm going to try and mute everybody anyway, not to get any feedback. The second scenario can be where there's a workplace closure. In other words, there's a site closure or a location has closed and it's not suitable for people to work at another site, and therefore you deem their positions to be redundant. Or the third scenario, which from my experience is actually much more common on a practical day-to-day level, the types of redundancies we advise on, a reduction of the workforce. In other words, there's a diminished requirement for a particular kind of work, either a contract that's funding a position has been lost, or there is just a reduction in demand for a particular role, perhaps because that role can be undertaken by somebody else, or 2 roles become 1, or 5 roles become 3, or whatever. But there is a fundamental reduction in the requirement for work of a particular kind. So as I say, that is the most common scenario that I encounter, certainly. So this is what underpins a redundancy. And I'll ask Fiona in a minute to delve into kind of the practical procedural steps you might take with a redundancy. But I think this is quite an important point to kind of pause and consider at the outset. Into which one of these does your redundancy fall if you're anticipating making a redundancy or redundancies? From a legal perspective, as an individual, it is quite difficult to challenge a redundancy where there is a fundamental legitimate purpose, there's a fundamental underlying justification for that redundancy. As somebody who sometimes acts for employees as well as employers, I always advise employees that, generally speaking, if an employer has got a sound justification for making redundancies, which is based on one of these 3 scenarios, then a redundancy is the most difficult type of dismissal to challenge. So as long as you get this bit right, this underpinning of the reason for the redundancy, the rest of it becomes more a procedural fairness issue as opposed to the fundamental fairness of the reason for the redundancy itself. So I'll now pass over to Fiona, who's going to walk us through the chronology, if you like, the life cycle of a redundancy process. No, sorry, I've got one slide before that, Fiona. That's a false start. Before I ask Fiona to do that, it is also worth pausing at the outset of any redundancy process. And before you get that far, you think, right, are there any alternatives to following that redundancy process. So is there anything we can do to prevent the need for redundancy? So it's only, a tribunal will expect an employer to have at least taken that conscious step to consider that before you take then the plunge into your redundancy process. And I just put some examples of things that employers might have in their minds on the screen there. If you are able to utilize the furlough scheme, and I accept that not all employers can because of funding streams and publicly funded roles, but if you can use the furlough scheme, should you consider whether you should continue to use the furlough scheme or start to use the furlough scheme right up until the end of September as an alternative to making positions redundant? I mean, I'm defending a number of tribunal claims at the moment, actually, from employees who have been made redundant, who are saying that they should have been furloughed. And my employer client's position is there is no automatic right to be furloughed, and that's true. It's at the discretion of the employer, but it's only fair and reasonable for an employer to have considered the furlough scheme. Other things that you might consider as alternatives: flexible working. Can you do a job share? Can you reduce the number of roles that way? Can you look at reorganizing things, restructuring things? Can you look at temporary salary reductions for a period of time? Of course, you would need an employee's agreement to that, or else you run the risk of enforcing a change and them potentially alleging that there's a breach of contract, or worse still, a fundamental breach of contract. Other alternatives are recruitment freeze, redeployment, or restrictions on the ability to take overtime. So those are just some alternatives that you might think right at the outset, right? Do we really need to go down this route? Or is there another route that we can take, or a combination of other routes? So Fiona, I think now is the time that you can come in on the process involved with the redundancy process.
Great, thank you, Owen. So good morning, everybody. My role today is now to walk you through the key elements as I see them to enable you to get a redundancy right as far as you possibly can. There will always be some issues and some difficulties in processes, but if you follow these principles, then you will do your utmost to get the redundancy process right. So the 5 areas I'm going to look at this morning: firstly, the business case, and that echoes what Owen said about getting the fundamental categorization of the redundancy right from the outset. The selection process that you need to go through, if indeed you do need to go through a selection process, because sometimes redundancies are of a single role. The requirements on you to inform and consult with individuals about the redundancy process. Confirming the decision and the implications of that, because often redundancies, especially where people have long notice periods, can be quite awkward for an organisation and also for the individual involved who's possibly lost faith in their organisation, doesn't really want to contribute to the role for the remainder of their notice period, etc. So what are your options there? And also then just a final bit on calculating redundancy pay. I know there are statutory calculators on the government website, but there's just a few points that I want to cover off on the calculation, which we will do at the end of this. So moving on to the business case then. So the business case, first and foremost, and this is what I always say to my clients, is that we need to understand very clearly what is the rationale for the redundancy. And as Owen said in his previous slide, it will be one of those 3 things. Is it a business closure? That's pretty straightforward, because then all positions are likely to be at risk of redundancy. Is it a workplace closure, so just a part of a business, so maybe just one office? Or is it a reduction in the workforce? And in my experience, the most common one is the reduction in workforce. So fundamentally, you need to understand what has changed, and therefore what is the rationale for the redundancy process and instigating that. And if you get that very clear from the outset, then that will help you define your redundancy pools. Because if you know that a particular stream of funding, for example, has come to an end, then it is very clear to follow on from that to identify, well, who was funded by that funding, and therefore they are the people who are at risk of redundancy. If it's an office closing, it's quite clear to identify the redundancy pools. But sometimes it just is a case of the amount of work that is needed to be done has reduced. It may be that you've had technological advancements such that you don't need as many people to deliver the same level of service. So it could be that a number of people in your administration pool, for example, will be affected. But fundamentally, if at the outset you get it clear what has changed and what needs to happen as a result of that, that will form the bedrock for your redundancy process. In my experience, where it's not clear, that then leads on to doubt from employees who are going through the redundancy process. And that naturally then gets them to start looking for sort of, well, actually, I don't buy that. I don't think there is a genuine redundancy case. I think you're just trying to boot me out. And so it just sets off the process on the wrong footing. So very clearly establish your rationale, define your redundancy pools, and confirm how many employees are affected. And certainly in your initial announcement letter, it should be very clear what the rationale is, how many people are affected. And as Owen was saying before, if you've got 5 people doing the same role, do you need to lose all 5, or is it 5 down to 3, 5 down to 2, whatever it might be? So you need to identify within each pool how many people are affected. But also then, if your redundancy basis is as part of a restructure of your organisation, so for example, you might have, and I'm going through this with one of my clients at the moment, they've got the wrong roles in a particular department, and they actually need to let go somebody at a middle management level, and they need to replace with somebody who can operate at a strategic level, but probably on a part-time basis, and then somebody at a lower level who can operate on an operational, organizational, administrative level. So that's a restructure. So you need to then think about, if you are losing a position, are you creating new vacancies within the business that you need to make these people aware of? And similarly, do you have any other vacancies within your business that you can make individuals aware of? It's very clear that when you are informing people about vacancies, that it should be the case of you don't judge, you let them decide whether or not they're interested in those vacancies. So if I can move on to the next slide, please, Owen, thank you. So then once you've got your business rationale, you need to think about, do we need to go through a selection process? Now, it may be that you're lucky and you don't need to go through a selection process because, say, it's just a pool of 1, or it's the entire population at a particular office, or let's hope it doesn't happen, but sometimes it does, that it's the whole business that is sort of going. So, but if you do need to go through a selection process, it is imperative, in my view, that you are very clear about the criteria that you propose to use. And I always put forward criteria as a proposal, and I include those as part of the consultation process with employees so that they can comment on the criteria that are proposed to be used. Very rarely do I find that anybody ever comes back and questions the criteria. And if you've thought through your criteria properly in advance, then it should be clear that they are linked to what the organisation needs to achieve at the end of the redundancy process. Again, in terms of the selection criteria, and sorry, I'm jumping around the slide a little bit, but what I tend to do with my clients is I split criteria into technical criteria, but also generic criteria. And typically then the generic criteria, things such as length of service, disciplinary record, absence record, etc., stay the same for any redundancy process that an organisation goes through. And it's then the technical criteria that would change. So the technical criteria, sorry, I'll put my teeth in, might or would be relevant to the job that is needed going forward. So it would identify the specific training, the specific skill set, the specific experience that's required. But you then have that constant in any redundancy process of your generic criteria. So as I said, the proposed criteria should be included in the initial consultation so that employees can comment on that. And once you've then gone through that and people have said, no, don't have any issues with that, you can then use those criteria. The criteria should be as objective and measurable as possible. That's not always going to be the case, because you can't always have just purely objective criteria. There will generally be some element of subjectivity. And so to try and counteract that, there's two things that I always recommend. The first one is that you have at least two people scoring, and those people should have equal knowledge of all of the all of the people in that redundancy pool, so that you don't, or you try and eliminate any bias. But also then you should make sure that your criteria are applied fairly and consistently, and that you document the rationale for giving somebody a particular score. Now, if you have an appraisal process that attributes scores or a banding to somebody at the end of that appraisal process, then that is a really good start point for scoring against a criteria such as standard of work performance, for example. But you could equally look at disciplinary record, the amount of supervision and intervention and support that they need compared to somebody else. But whatever you do, whenever you're applying selection criteria, apply them fairly and consistently, because this is the area where invariably, if somebody's not happy with their selection for redundancy, they will look at this area to try and establish they've been treated unfairly or discriminated against. So document why you're scoring people a particular score. So if I can move on to the next slide, please, Owen. Thank you. So also when you're considering sort of your redundancy pools and your redundancy process, you should consider whether or not you've got alternative employment. It's almost a sort of carrot that you can dangle to people to say, well, okay, we need to make your position redundant, but we do have these vacancies. Now, alternative employment is split usually into two categories. You have what's called suitable alternative employment, and you have alternative employment. Alternative employment is easy. It's just any vacancies you've got within your business. Suitable alternative employment has more meaning in a redundancy process and also in employment law. So suitable alternative employment is a job that an at-risk employee could slot into with minimal training. And to determine whether or not a job is suitable alternative employment, you should consider the rate of pay, the skill set that would be required to do that job, the seniority, and the location and hours of work of that particular job. Now, in terms of pay, unfortunately, there's no magic figure to say, well, if this new job or the alternative employment that's on offer there's at least a 15% pay differential, then it's not suitable alternative employment. There is no magic figure, and certainly what a tribunal would look at would be looking at everything in the round. But certainly if there's clear water between the rate of pay of the current role that is being made redundant and the new role, then that is one potential indicator that it is not suitable alternative employment. Similarly, if the skill set is significantly different, it wouldn't be suitable alternative employment. If there's a significant difference in the seniority levels, so depending on the number of people that they may have to line manage, their decision-making authority, etc., that could be an indicator of not being suitable alternative employment. And if you've got a home-based employee and the new role is going to be office-based, again, that could be an indicator that something is not suitable alternative employment. If something, having looked at all of that, is considered to be suitable alternative employment, the impact of that is that you are obliged to give anybody at risk of redundancy first refusal on those jobs. Now, there is also then an additional level of protection for anybody who's in a redundancy pool, so in an at-risk group, who is on maternity, adoption, or shared parental leave. Those people have additional protections, and they are entitled to first refusal on any suitable alternative employment ahead of anybody else in that redundancy pool. There was legislation that changed back in 2019 that extended the protected period. So from the point in time that somebody is pregnant and tells the employer that they are pregnant, up until 6 months after the end of their maternity leave, that individual has the highest level of protection with regard to redundancy, such that if there is suitable alternative employment, that individual would be given first refusal on any suitable alternative employment. Also, an impact of suitable alternative employment is if an employee unreasonably refuses that suitable alternative employment, then they could lose their right to statutory redundancy pay. Unreasonably refusing is not defined in employment law, and that would be down to a discussion between you and your legal advisors as to whether or not you choose to rely on that. And also, if there is suitable alternative employment, an employee has a statutory entitlement to a 4-week trial period to determine whether or not that suitable alternative employment suits them. And that trial period works both ways. It's for both the employer to determine whether they're suitable for it, and the employee to determine whether or not they want to continue in that role. And if the trial is successful, then that's fine, and it's not a redundancy situation, and no redundancy pay is payable. But if that trial is not successful from either party's perspective, then the employee continues to be made redundant and is entitled to the statutory redundancy payments, sort of as we will come on to. If I can have the next slide, please, Owen. So the next step, and this is where I wanted to sort of walk you through the meetings that I would typically have in a redundancy process. People often ask me, how long do I need to consult for? Well, it depends on the number of people that are potentially to be made redundant. If you've got 20 or more people who are due to be made redundant, then you need to consult for a minimum of 30 days. If you've got 100 or more people that are due to be made redundant, you need to consult for a minimum of 45 days. Anything fewer than 20 people, there is no minimum consultation period, but you just need to undertake what's determined as a meaningful consultation period. So don't go into your first meeting presenting something as a fait accompli. You should go in there with a genuine need and desire to consult with people about the proposed redundancies. If you've got 20 or more people who are looking to be made redundant, then you will need to report to the Secretary of State, as Owen said at the outset, of your intention to make that number of people redundant. And that's what drives the statistics that we were talking about before. So moving on then to the process, I always advise my clients, before you even send the balloon up, you need to have drafted your initial announcement meeting letter, because that effectively drives the agenda for what you discuss at the initial announcement meeting. And that very clearly sets out the business rationale for the redundancy process and the potential impact of that on the groups of individuals. So it states the reason for the proposed redundancy, it states the redundancy pools, and it states the number of people from each of those redundancy pools that are at risk of redundancy. It also then states the process that you're going to follow as a result of sort of that announcement. So typically I would include the criteria if you need to go through a selection process, so that you can say to people, these are the criteria that we will go through, but we will consult with you about those. It would also then state any arrangements in relation to redundancy pay. I think, again, in my experience, the first question, once you've mentioned redundancy, the first question that people always want to know is, what am I going to get? And so I always think it's sensible to state that if redundancies are unavoidable, then this is the payment that we will be giving. And in most cases, that will be statutory redundancy pay. But if you are contractually obliged to pay more than statutory redundancy pay, then that's what you will need to do. Now, we don't have a huge amount of time today, so I'm not really going to sort of go into any great detail about volunteers for redundancy, but certainly if you as an organisation are thinking that you might consider volunteers for redundancy, then you can include that in the letter as well. A word of caution here, and I would always say that sometimes it's a case of be careful what you wish for. People, again, in my experience, who tend to volunteer for redundancy are the people with a lot of service, and therefore the people who are expensive for an organisation to let go and make redundant. And they often tend to have a lot of notice as well. And typically, if somebody is volunteering for redundancy, you would sort of consider whether or not it's fair and reasonable to allow them or to require them to work the notice period. So it could be quite an expensive process if you accept all those people who volunteer for redundancy. You also need to think about the skills drain that you might have. And again, in my experience, the longer serving people, the more experienced people tend to have a greater skill set than perhaps some of your newer recruits. And therefore, if you accepted everybody who volunteered for redundancy, then you may find that you've lost a lot of valuable knowledge from your organisation. You're not obliged to accept any volunteers for redundancy, but if you do choose not to accept somebody who's volunteered for redundancy, and you then subsequently make redundant somebody who hasn't volunteered for redundancy, and that person is in the same pool as the person who volunteered and has been turned down, you will need to have a very good business reason as to why you have done that. And you should document that as well. It's not to say that it's going to be unfair, but you should document your reasons. And it may simply come down to, we can't afford to lose the skills, or we can't afford to pay the redundancy pay for this particular individual. But you need to have a business reason rather than just thinking, no, we're not going to do that just because we don't like them. So once you've drafted your initial announcement meeting letter, that forms the basis of your initial announcement meeting. And I would suggest that you then use that as your agenda. And then you can send out that letter to everybody once you've had the initial announcement meeting. Once you've had the initial announcement meeting, you then need to arrange consultation meetings to consult with the individuals about the proposed redundancies and see if they've got any ideas to avoid the need for redundancies or to minimise the impact. So you may have, and I had this a number of years ago now, in a law firm where they needed to make some redundancies in a particular department, and they said, we have got 5 people doing this work in this department and we actually only need 4. Now, as a result of that, and this was back sort of when we had the crash and the financial crash, and it was a law firm that was dealing with sort of conveyancing, and so a lot of people stopped moving house, and therefore they didn't need as many people in that department. As a result of the consultation process, the 5 people in that particular department said, we can see that there's going to be an end to this at some stage in the not too distant future. So what we've all agreed is that we will all reduce our hours so that the cost saving you achieve, Mr. Employer, but nobody loses their jobs. And actually that worked out very well for them, because 6 months down the line, they were able to put everybody back up onto their full hours. So there is a genuine purpose for the consultation process, and you should, as an employer, listen to any objections or proposals or ideas and respond to them. You should keep a record of those proposals and make sure that you respond to each one. And if it's the case that some are good ideas and can be taken forward, then of course you do that. But if they're not viable suggestions, then of course you need to explain to people why they're not viable. Now, I say there to consult with employees or their representatives. There is a legal requirement for employers to consult with employee representatives in redundancy situations rather than a group of 30 people, for example. It makes it more manageable, but also puts the onus on those representatives to convey information back to the people that they represent. And I would always recommend that you take charge of that communication process. So you prepare information that can then be issued to the representatives, who then pass that out to the people that they represent. Once you've gone through the consultation process and there's no viable alternatives to avoid the need for redundancy, you then need to hold formal individual meetings with people. And at that point in time, you would be giving them their scores. So if you have had to go through a selection process with criteria, then I always give people their scores before I've told them whether or not they are in the at-risk group, so that they don't know whether they are challenging for no reason because actually they're safe, or whether they're challenging because they are potentially at risk. And so it allows everybody an even playing field, and people can then challenge their scores, again, right back to them to say, you challenged this, we've changed it for this reason, or we've not changed it for this reason, and then it's all documented. But you go through those meetings, and then you can confirm you've had the opportunity to challenge your scores. Unfortunately, you remain in the at-risk group, and I'm now inviting you to a full redundancy meeting at which you have the right of representation to then, in the absence of any changes, give you notice of redundancy. If I can have the next slide, please, Owen. So we are in an unusual situation, and I just wanted to flag up a couple of things for carrying out redundancy meetings whilst we are still in lockdown. There is no legal requirement for consultation to take place face-to-face, so you can have redundancy meetings, and indeed I've had a number of them over Zoom and Teams and WhatsApp calls as well. You should consult with employees about their preference. So if you do have a COVID secure workplace and people would prefer to meet face-to-face, then you can do that. But make sure that you comply with your workplace risk assessments and adhere to social distancing when you do that. As I've said, there is technology available to do that. And as Owen has already mentioned, if somebody is furloughed from your business at the moment, then that consultation process on redundancy is not considered to be work under the coronavirus job retention scheme, and therefore it doesn't negate furlough. So they can still be on furlough whilst attending consultation meetings. And for virtual hearings, and I've done, as I'm sure many of you have, a number of virtual meetings during the lockdown, including a number of disciplinary hearings, grievance hearings, etc. We are recording this session today, and Owen announced right at the outset that we are recording the meeting. So people need to be aware if you plan to record the meeting and consent to it. Be mindful of the possibility of covert recordings. In reality, there's not a lot you can do about it. It's very easy, for somebody to switch their phone on record and have it sat alongside their computer, and you're going to be none the wiser. So all I would say is plan for the worst and assume that somebody could be covertly recording something, and therefore just mind your P's and Q's and be careful what you say. Again, there may be undue influence, usually in any redundancy meeting, until you get to the sort of formal notice of redundancy meeting. Employees don't have the right of representation, but sort of in a Zoom or a Teams meeting, it's very easy for somebody to have somebody sat behind their computer that is giving them sort of guidance on what to say. It's usually quite easy to spot that because there's noise in the background or the individual keeps looking beyond their computer screen. It's up to you whether you choose to challenge it. I would say there's not really much you can do about it, and what's the benefit of you challenging it? It just makes everybody feel awkward, and I would suggest if you wanted to challenge it, you can just say, is there somebody else in the room with you? I thought you said you were on your own because you keep looking over your screen. But if they say no and you still think that there's somebody else in the room, it's not really going to affect the outcome of the meeting, provided you've planned for the worst and you're minding your P's and Q's and being careful what you say. With regard to video, consider your video requirements and what to do if somebody doesn't wish to turn their video on. I had a redundancy final meeting with somebody a while ago, and I said, can you hear us all right? Because we're having difficulty hearing you. There's a lot of noise in the background. He didn't have his video on, and he said, oh, that's because I'm in a beer garden of a pub. Remember those days when we could go to pubs? But you know, there's nothing I could do about it. He chose to be in a public space. He was annoyed with the company and annoyed with the fact that he was being made redundant, but I couldn't do anything about it other than just check to say, are you happy where you are and being in a public space? And he was, yeah, just get on with it. So you will have people like that, I'm afraid. But it just goes to the final point, ensure parties are in an appropriate setting to minimise noise and disruption. In terms of confirming the decision, determine the notice period. That will be set in people's contracts of employment. If not, it will be the statutory, which is sort of 1 week for every complete year of service, up to a maximum of 12 weeks. But also look at contractual entitlements. Often people that I speak to say, yeah, we need to let this person go, we need to make them redundant. And I say, okay, well, do you want them to work the notice period? Oh yeah, I want to work the notice period. So consider the practical implications of that, but also consider, do you have the contractual entitlement to put them on garden leave? Do you have the contractual entitlement to pay them in lieu of notice, rather than having somebody who's not really fussed on being at work, but being forced to be at work for their notice period? Also consider what your contract says if people are entitled to benefits during the notice period. For example, car allowances, company cars, death in service benefit, private medical, those types of things. Do people still receive the benefit of those things during any period that they're under notice? If they're still employed, then technically, most of the time, I would suggest they probably are. And also, do you have provision in your contracts to allow you to compel people to take holidays during the notice period? If you're making redundancies because you need to save costs, then being faced with a bill of having to pay somebody holiday pay on top of the notice pay and on top of redundancy can be quite crippling for some businesses. So think through these things before you have that final meeting with somebody and before you tell them the practical arrangements with regard to the notice period. Confirm the decision in writing and make sure you give the right of appeal, and that should be in line with your sort of procedures with regard to redundancy processes. And then finally, calculating statutory redundancy pay. There is a link there on the screen to calculating it using the government website calculator. Just a quick run through this. Somebody needs to have at least 2 years service in order to qualify for statutory redundancy pay, and the maximum number of years of service that will contribute towards their redundancy payment is 20. There are age bands as well, so young people will only get half a week's pay for very early or years of service when they were young, 1 week's service for a sort of substantial chunk of time between 41 and look on the redundancy pay calculator, it's easier. But weekly pay is capped at £544 per week. That changed as of April, so this month. That tends to be reviewed each April. As Owen alluded to earlier, full pay should be used as well. So even if you've got somebody who's been on furlough or had a period of sickness absence, their weekly pay should be determined by their normal full pay, their contractual pay. Now, for people whose pay is fixed and you pay us the same amount from week to week or month to month, their weekly pay is simply their gross salary divided by 52. But if you've got somebody whose weekly pay varies because of the amount of work they do, then you should use a 12-week average. Statutory redundancy pay is free of tax for the first £30,000 and national insurance. It should be paid with the employee's final pay, but also just check your contracts to see if you have included any provision for contractual redundancy pay. So some employers, typically the larger employers, will enhance the redundancy pay. So they may say, we don't place a cap on weekly pay when we're determining redundancy pay. Some people give a multiplier. So just make sure that you are adhering to any contractual requirements you have for redundancy pay. So that's a quick run through all of that. I'm now going to hand over to Owen to talk through the doom and gloom of what happens if you get it wrong.
Yeah, I've got one slide left, and it's a bright and cheerful one to send you on your merry way, and it's about the risks of getting it all wrong. As I mentioned at the start, and I'll briefly touch on this, as I mentioned at the start, looking at this from an individual's perspective as much as from an employer's perspective, a redundancy is actually From a legal risk perspective, it's not risk-free. Of course it's not, hence the slide. But it is the safest of all the dismissals you can carry out in many ways, in that from an individual's perspective, if a redundancy is done properly, it's very difficult to challenge it. And there are two fundamental elements to a fair, sound, safe redundancy. And those are that there is a fundamental, genuine redundancy rationale, and that the process is carried out fairly. So naturally, the risk areas for employers are linked to those two things, and therefore under the heading of unfair dismissal, which by the way somebody needs 2 years service in order to bring an unfair dismissal claim, but if they've got more than 2 years service, there are essentially two ways that they can challenge a redundancy. They can say there isn't a genuine redundancy here, it's all predetermined, it's just a way of getting rid of me. So that the way you avert that risk is you get your fundamental rationale for the redundancy right at the start. You put it in writing, and that underpins everything that is to follow. And if it falls into one of those three categories I mentioned at the start, then everything should flow from that, and you should have no problem with people challenging the genuineness, the legitimacy of the rationale for redundancy. The second one is all about procedural flaws. I mean, if you follow Fiona's advice there along the line, then you will have no issue with that. But sometimes people try and unpick aspects of selection criterias, or you know, the not having the right of a companion, or not enough consultation, or not enough meaningful consultation, or not enough of an effort to look for alternatives to redundancy. So it's all, everything that Fiona's mentioned now is about averting that second risk. Onto discrimination, which, by the way, you don't need 2 years service as an individual to bring a discrimination claim. Essentially, two of the main risks that can be flagged here are the first point there, which is Fiona's mentioned that there is additional protection for those who are pregnant or on maternity leave in redundancy scenarios. It's one of those very rare cases in employment law where positive discrimination is legislated for. So it's just be mindful of that, and not to fall foul of that. And secondly, as well, there's a bit of a risk area with selection criteria sometimes, where if you've got, say, a selection criteria that says we take into account your sickness absence, then somebody who is deemed disabled under the Equality Act, has got a long underlying condition, might say, well, that discriminates against me and my disability, because I'm placed at a disadvantage because I'm naturally going to have more sickness absence. The way to alleviate that risk is to discount any disability related sickness. So if somebody, say, has been for cancer treatment and has had a lengthy period off work, then you would take a view that you are actively, and you inform them of this, you discount that period of sickness linked to the cancer, in order to alleviate the risk of them saying this is disability discrimination. So that's all I've got to say on that. And then we've got the final slide there to say thank you for attending, which I would just reiterate. We've got a couple of questions. I think the first question on the chat was sent to me by direct message. I'm not sure whether you would like to come in here. I know it's YK, and it's a question for Fiona, I think, about technical criteria.
Okay.
Do you want to come in?
Hello, can you hear me?
Yes.
Hi.
Yes.
First of all, thank you very much for doing this and taking the question. I want to ask if the employer could decide that a business degree is not relevant to the business itself, which, for example, it was a hospitality, and the employee was working in their corporate HR function. So what happened is that we decided that for that specific employee, the business degree is not relevant to the business. Personally, I thought that it was kind of wrong, but we were backed up by our legal lawyers. I just want to ask a little bit more about that, if you have any insight. Thank you.
Okay, thank you, YK. I would say that ultimately, your selection criteria should be able to stand up to scrutiny to as to whether or not they are relevant to the role that remains after redundancy. So if, for example, this was a restructure and you had a number of people who were at risk of redundancy and they were all applying for a new role, if the new role needed somebody to be educated to degree level for the sort of attributes that that brings, or an equivalent level, but not necessarily a degree, then you should be able to demonstrate why that is necessary. Now, in my experience, I haven't seen for sort of jobs that aren't purely technical. So for things like, you know, a lawyer would need to have a law degree. Accountants generally need to have some sort of finance degree. HR, and because that's my own field, my degree is in chemistry and food science, so that's absolutely nothing to do with HR. And I would say that it's one of those things that it would be fair and reasonable for a business to consider whether or not somebody educated to degree level or equivalent would be required, but not necessarily to specify the nature of the degree, unless they can establish that that particular degree is particularly relevant to the role that remains. I'm not sure if I fully answered your question, YK, but by all means come back and comment.
Yeah, of course, that was great. Yeah, thank you. Because the what happened was that the employee had one business degree and one CIPD level 7, and we had another employee who had a hospitality degree and a psychology master's. So we chose the second employee, and we decided to proceed with the redundancy for the first one.
Okay, I hope that you had a number of other criteria that you used as well, and assessing their ability and their skill set.
We'll take that as a rhetorical question,
Yeah.
I think, Fiona.
Okay.
So I've got a, sorry, do you want to come in there, YK, or can I move on to some of the other questions?
Oh no, please move on. Thank you very much.
Thanks a lot. So there's a question from Alison about somebody having 5 years service with an employer, but a new contract that has been in place for less than 2 years. And on what basis is the statutory redundancy payment calculated? It's calculated on the entire length of service. So irrelevant of the length of time a particular contract has been in place. If somebody has continuous service dating back 5 years, then that will be the reference point for redundancy payments. In order to break the chain of length of service, in order to break continuity of service, you need a break of at least 7 clear days in your employment, but you need it to genuinely come to an end. So you need your employment with the employer to genuinely end, and then for a clear 7 days to happen, and for them then to restart employment afresh, in order for there to be an effective break, and then for redundancy pay to be based on the second period of service. I hope that answers that one. I'll just answer the next one as well very quickly from Eileen, and it's to do, so Eileen has mentioned that again, a question about redundancy pay, with pay scales being aligned to NJC scale. Yeah, obviously that isn't decided until September. What if staff, presumably you mean, what if staff have been made redundant prior to September, and have been made redundant presumably with redundancy pay based on their salaries pre-September? Do they then have a challenge to say, I should have got a bit more redundancy pay because my salary would have gone up in September? The answer to that is no. The redundancy payment is, and notice pay, whatever, is based as at the date of dismissal. And if the date of their dismissal is pre-September, then their redundancy payment is based on their basic salary as at the date of them leaving, as at their last day of employment. I hope I've answered that one fully. If not, please come back on the chat. Fiona, do you want me to read the next one? So there's one from Jan about, in a restructuring situation, if a post is created which adds additional responsibility to a role, but at the same seniority level, but at full-time rather than part-time 4 days, does the employee lose their right to redundancy pay if they don't wish to undertake that role?
Okay, thank you for the question, Jan. What I would, just on initial reading of that, is I would suggest that the more senior role is not suitable alternative employment on the basis that it is full-time rather than part-time. So the fact that it adds additional responsibility, if it were the case that that was the only change and you're effectively making a bigger role and that was capable, or the person in the role at the time was capable of taking on that additional responsibility, then I would say that that would be suitable alternative employment. But the fact that you're adding an extra day to it, I would suggest means that it's not suitable alternative employment, and therefore if the employee chooses not to apply for it or says that they're not interested in it, then you would have no option but to go down a redundancy route. You couldn't force them into that. Would you agree with that, Owen?
Yes, I would.
Yeah.
I think there's one follow-up question. I mean, Alison, you make the point that there was only a day break between two contracts, so that wouldn't be enough to enforce a break. So it would be a lengthy umbrella continuous period of employment. There's one further question from Alison about 0-hour contracts and what figure you base it on. I mean, with 0-hour contract, if they are genuinely 0-hour contractors, then they technically are not deemed employees. They are deemed workers, and worker is, I mean, we could do another session on this, but worker is kind of like a hybrid between an employee and a self-employed contractor. This is all to do with the Deliveroo and Uber recent case law course. A worker, which sits in the middle, has no right to a statutory redundancy payment. So unless you've got something in their contracts or in a policy somewhere to say that they are, by law, by statute, there is no right to a redundancy payment if you are a 0-hour worker. But that is only if they are genuinely 0 hours. If they are genuinely a 0-hour worker, sometimes people are on 0-hour contracts, but actually they perform regular, consistent hours and have done for a long period of time. So they've got an argument to say, well, actually, I've become an employee because it's now a regular pattern and there's mutuality of obligation is the legal phrase. Basically, I'm expecting work all the time and I'm expected to perform it all the time. So that's the risk area, is that in practice, if the 0-hour worker has actually become an employee, it then becomes a bit of a grey area, and you would say, well, actually then, as at the date of them genuinely becoming an employee, they should be given an employment contract then to reflect that arrangement, and only then will their time start for calculating 2 years for then a redundancy payment. But if they are genuine 0-hour workers, there would be no right to a redundancy payment. That answers the question.
If not, just come in on that one as well, just to add to what Owen said, that if you do determine that yes, they are sort of an employee for the purposes of this and therefore entitled to a redundancy payment, if their pay fluctuates, then you should be using a 12-week average. So an average of the 12 weeks pay prior to the 12 weeks prior to the date that you give them formal notice of redundancy.
Yeah, so that would be similar to sort of genuine employees who just have hours that vary. You use that 12-week reference point. There's one point from Victoria here, which is not a question but a point on the previous point. We had a similar situation where the alternative employment was 5 days instead of the redundant job, which was 4 days, and the person couldn't do 5 days because of disability. So we were advised that it was a suitable alternative and we should try and accommodate it. I accept that's okay. That's a good point to flag. If there are any further questions, please let us know. I'm sure Fiona and I will just stay on the line for about a minute. If there are no further questions, then thank you for your time and thank you for listening and thank you for being engaged and asking lots of questions at the end. That was really, really great. As I say, the slides are available. The recording is available if you want to share it with anybody. So please, please get in touch. I mean, for that purpose, actually, if I go back and I put our email addresses up on slide on screen. Perhaps if you just contact us, either of us or both of us, asking for a copy of the slides and the recording, and the slides we can send now. The recording will just need a little bit of editing by our marketing people, I think, before we can send that out, but it will follow the next couple of days. So I think that's all, and thank you for your time.
Thank you, everybody.